So today we're going to talk about legal malpractice. It's going to be a kind of deeper dive, longer form video. And it's because I get a lot of calls on this and find myself explaining these concepts over and over again. So I thought it would make a good video for the people out there who are curious about legal malpractice. Maybe you're looking for a lawyer for legal malpractice. So let's start with the basic elements, okay? Legal malpractice is basically just a negligence claim against a legal professional. And it is basically the same thing as medical malpractice or accounting malpractice or tax professional malpractice. The elements are generally the same. You have to show that there was a duty of care, usually that you had a professional relationship with this lawyer, etc., that there was a breach of that standard of care. In other words, that the lawyer made some kind of mistake, and we can talk in more detail about that, but that is usually some kind of mistake that isn't a question of judgment, isn't a question of strategy. A mistake that is always a mistake and can't really be debated about. Then you have to show that that specific legal malpractice or that act of negligence, the breach of the standard of care, caused an injury that wouldn't have otherwise occurred. So it's sort of causation and damages. Causation and damages can be their own kind of massive battle, and we'll talk about that in a little bit more detail. So let's go kind of one by one on these elements, right? I talked a little bit about how the first question is whether there is a duty of care, whether there is a professional relationship. And in most cases, you can kind of skip this element because it's very obvious. You have a fee agreement, you have an engagement letter, the lawyer is handling your case and they make a mistake. Sometimes if there's some advice that's given, maybe in a somewhat more informal setting, there can be a debate or a question or an argument about whether there was in fact an attorney-client professional relationship. This came up in an accounting malpractice case that I had where there wasn't an engagement letter, and we spent half the mediation arguing about, well, were they even really the accountant on this case? So that's how that can come up. And the next thing is, of course, the breach of the standard of care. So let me give you a clear-cut example. If it's a personal injury matter and the attorney misses the statute of limitations, doesn't file the case on time, there's no debate about that. There's no question, there's no argument that that is below the standard of care. You don't have some sort of professional judgment in whether to comply with a deadline like that. Okay, so that's like, can't be debated, textbook, 100% of the time, that's negligence. You get into some other issues though. What if it's a failure to advise, or maybe it's a waiver of a claim? Maybe the attorney decides, I'm going to drop this particular claim. Well, that may be malpractice, but it may not be, depending on whether that claim was good. You get into questions of strategy. Can you strategically make certain decisions as a lawyer that maybe don't result in great outcomes for your client, but are nevertheless not malpractice? So you can get kind of a debate and an argument over that zone of, well, what is the proper attorney judgment call here? Is this a question of professional judgment? Is it kind of reasonable lawyers could disagree on this and choose different courses of action? It's not as simple as, well, the best lawyer would have done X, Y, Z. That's not the question. The question is, did you get kind of minimally competent, reasonable attorney representation on that particular issue? So, it's going to depend a lot on what was done or not done. So usually we have both of those things. We have a legal relationship. Part one, you need a duty. Part two, you need some sort of breach of that duty, whether that's, you didn't serve the complaint within a year. In Tennessee, we have a rule that you have to serve the complaint within a year, and if you don't, it's the same thing as blowing the statute of limitations. So, those sorts of things are usually pretty clear-cut. Here's where it gets really difficult. Is, okay, I refer to this as the so what problem. So what? So you had a legal relationship, so the lawyer blew the deadline. Now we have to peel back the layers of the onion and look at the underlying case, that the lawyer represented you on. And we have to kind of think through how strong that case was. And this is sometimes called the case within a case. You have to kind of look at, well, what was going to happen in the underlying lawsuit? If it's a car wreck case and the lawyer blew the statute of limitations, doesn't mean you're entitled to bring a legal malpractice case if you are the one that ran the red light, for example. If it turns out that liability was questionable, if it turns out that there was some sort of immunity defense. Give you an example. We had a case where an attorney blew the statute on an employment discrimination type matter. So it was definitely legal malpractice. But there was this whole question of how strong was the employment case, right? I mean, the interesting thing about legal malpractice is that when you sue the lawyer who presumably represented you on your underlying case because he or she thought it was good, or maybe it was an hourly thing, but either way, they were making all the best arguments they could in your favor. Now, because you've sued them, they're entitled to make every argument that the defense would have made in your case. So it puts them in a totally opposite position from what they were in when they took your case, when they were representing you. They were representing you, they were advocating for you. Now that you've sued them and said you messed up my case, they get to make all the arguments that the defense would have made. And we, as legal malpractice attorneys, have to then defeat those arguments. So it's the case within a case. We are litigating the legal malpractice claim at the top level, but then when we get into, well, how strong was this underlying matter? You know, what were you likely to recover? What was the outcome you were likely to have? How did this legal malpractice affect that? That's where it gets really complicated, is on causation and damages. On damages, let me give you an example. I'll circle back to causation in a second, but you know, sometimes you have this situation. Lawyer makes some terrible mistake, but it can be appealed. Maybe you have an argument on appeal that can fix the malpractice. So now you have this awkward thing where the lawyer has messed up, and by the way, your statute of limitations is running from when you know the lawyer messed up. You can't wait to see what happens on appeal. The clock is ticking. But it could be the case that the appellate court reverses the trial court and fixes the problem for the lawyer and for you. And then there's no point in bringing a legal malpractice case. Yes, maybe the lawyer messed up. Yes, maybe you incurred, appellate fees, which that would be a discrete kind of damage, having to pay your lawyer to do the appellate work. But if they fix the problem, then it doesn't really make sense to bring a legal malpractice lawsuit, because now you're basically you're restored to the same position you would have been in without the malpractice. So we are always looking in legal malpractice cases for the very specific connection between the attorney's malpractice and the injury to you as the client or the former client. How did the mistake harm you? And I get calls all the time on, for example, family law matters, divorce matters. An attorney didn't, file the right paperwork, and it may result in, say, a denial of alimony, just to give you an example. But it may be that there's an appellate issue on that, and that award of alimony could be restored for other reasons. So, then it doesn't make sense. The same thing in a probate matter. It could be that, there's a distribution that's ordered, or some sort of change in the estate. But if it can be remedied within the probate court or the appellate courts, then there's no real point in a legal malpractice lawsuit. So talking about the damages that you can get in a legal malpractice case, they're not exactly limited to the damages of your underlying case. Say you had a $100,000 car wreck case and the lawyer blew the statute of limitations, you get, the $100,000 that you would have gotten. Some cases it's not as clear. Some cases you may have paid the attorney hourly fees, then the attorney didn't do what they were supposed to. So you can recover those fees on top of kind of what was the position you were supposed to be in if you'd gotten competent attorney care. You can also, at least in Tennessee, potentially recover emotional distress from the whole episode, having a lawyer, mess up your case. There's kind of a pain and suffering element that you can allege. You can often argue, and it's not been conclusively established, at least where I'm licensed. Some jurisdictions have, so you'll want to check this. But, some cases have settlement value, even if you wouldn't necessarily win them. You can get a kind of settlement outcome, compromise, even if maybe you weren't going to win the case at trial. And we would always argue that that is recoverable. If you were deprived of the opportunity to settle your case, you should be compensated for that. One school of thought says, well, the only way to know is that you actually have the underlying trial on the case. You put on a kind of mock trial of the underlying case, and the jury decides. It's not totally clear to me what the outcome or what the process is in a situation like that. It's a little bit of a nebulous thing. If you're saying, well, maybe I wouldn't have won this case, but they certainly would have settled it, and you didn't, allow me to get the settlement, you should be able to recover for that. In some jurisdictions you can, I think in others you can't. So just be aware of that. It's a little bit of a weaker claim, frankly, if it's not, I definitely was going to win my case, or I had a really solid case. Liability was clear. The guy ran the red light, whatever. A case where maybe liability is a little bit more disputed, but there was still some value in settling it. If that kind of case is messed up through attorney malpractice, you should still be able to recover. It's just maybe a little bit harder. So anyway, I hope this has been a helpful overview of legal malpractice, some of the issues that come up, just kind of a broad level thing. If you've got a specific legal malpractice case, absolutely give us a call. Put a link below this video. One thing I'm almost certainly going to ask you would be, what's your statute of limitations? So what's the malpractice that occurred? When did it occur? And when did you learn of it? Does your state have a statute of repose, right? What's the statute of limitations for legal malpractice? Is your claim timely? That's like question number one before we get into all the stuff I've been talking about. So just kind of be aware of that. But I'd be happy to help if I can. And, comment down below if you've got any thoughts or questions on legal malpractice. Anyway, if the video has been helpful, like, subscribe, and let us know if we can help. Thanks for watching.